Welcome to the DTOS News Desk webinars. Thank you so much for taking the time to join us today. And as we bring clarity around this topic, Mauritius on the EU blacklist, consequences and the way forward. My name is Mark Morell. I am the marketing manager of the DTOS group, and I'll be your host this morning. We're going to circle this proverbial runway while we allow everyone else to join in and dial in into the webinar. I'm also going to use this time just to let you all know that my knowledge on this topic is limited to what I've read in the media, as well as more recently what was published by the Mauritian government. I'm not the expert here. I'm merely here to learn as much as possible, as are all of you. And but before we hear from our expert panelists, a few things I'd like to go through that help with running a successful webinar. First one is, feel free to add comments. We want to hear from you, our audience. If you like what someone is saying, tell us. So, I mean, we can try it right now. We can have a look on the screen. Give us a thumbs up so we can see you in the comments section. Give us a wave. If you like what one of the panelists have said, please feel free to add comments along in the bottom and we can see. Check you guys out. That's awesome. It's really good to see a thumbs up. Great. I got a wave from Les. I got a thumbs up from Roshan. Thank you very much. Right, the other one is that we'll be curating questions for the panelists at the end for our Q&A session. So we obviously want to bring as much clarity as possible. If your question is answered already through this discussion that we have, we obviously will not repeat the question at the end. Each guest has a limited amount of time to answer the questions. So our moderator, Lena, the one behind the scenes that you don't see, she's going to help keep us on track and ensure that we stay on track for the session. And it's also just to be noted that the session is being recorded. And for you guys watching on your computer or whatever device you're using, please close all other tabs to ensure that you have a really good stream. Great, so I think we're waiting for 1 or 2 minutes more before we get into it. But right now, let's get into our panelists. To my left, Mr. Jimmy Wong, the CEO of DTOS. Guys, if you can give us a wave to the camera, to the audience, and say hello. So, Mr. Jimmy Wong, thank you. Mr. Guillaume Ollivry, CEO of FIU. Hello. Yep. Mr. Nicolas Richard, Managing Partner of Juristconsult Chambers. Hello. Mr. Faraz Rojid, Head of Financial Services of EDB. And Mr. Yogesh Gokool, Head of Global Business at AfrAsia Bank. Great. All right, guys, so let's get into it. Let's start the question. Let's start unpacking this topic. I think we can all agree that Mauritius being put on the list has taken all of us aback. Despite the fact that many people talk about it, we realize that few understand the reality of the situation, and there's a lot of misconception around this topic. So it appeared crucial for us to start with a bit of clarity and context around the topic. So Guillaume, please, can you help us understand how we got to be on this list and the current situation? Perhaps take us back to a time before the announcement and how Mauritius was tracking.
Oh, thank you very much for the question. So I think when you say that we were taken aback by this listing by the EU, well, so were we at the FIU and many authorities, and not just Mauritius, but many countries also on the list. You can read this in the press. Yes. Essentially, if you read the Article 9 from the EU directive on AML-CFT, it says that the EU is empowered to list countries which present a risk to its financial system. This is not anything new. This is something that exists also under the FATF recommendations, which are the international standards. Recommendation 19, which talks about making a list of high-risk jurisdiction by particular countries and jurisdiction which pose threats to the country, etc. Okay. So this list comes out, and the thing that surprised us with the list was that the methodology for making the list came out at the same time. Right. Which was a bit strange because we thought, well, how can you make a list and publish the methodology at the same time? I mean, yeah. Turns out what has happened is that the EU essentially treats the FATF list, on which Mauritius already was, the FATF list as a list which by default poses a threat to the EU. Okay. As a market. And we thought that was a bit strange because not every country is exactly the same in terms of the deficiencies, etc., on the FATF list. But they did that, and they simply took the FATF list and repurposed it as the EU list. Which means that if the corollary to this point is that if you get off the FATF list, you should get off the EU list. So how did Mauritius get on the FATF list? This is the main question, the main topic that we have to explore, because one leads to the other. Well, the FATF, for those watching who are not familiar with the process, the FATF is the standard setter for anti-money laundering legislations and also the implementation of those laws around the world. The idea is to have a single system which is similar in all countries to avoid people from going from one jurisdiction to the other and taking advantage of weaknesses in different jurisdictions. So that's the basic idea. And the FATF has a system of evaluations called mutual evaluations, so assessing countries on the level of compliance. Mauritius falls under a regional body because the FATF doesn't go around and assess all the countries in the world. There's too many of them. So FATF relies on regional bodies called FSRBs, FATF-style regional bodies, to do the assessment at the regional level. We are members of the ESAMLAG, which is the Eastern and Southern Africa Anti-Money Laundering Group. So in 2012, 2013, the FATF revises the standards and its methodology. The standards come out in 2012, methodology 2013, because one thing that they noticed was that everybody was becoming compliant. What they were doing is that they were simply copying and pasting the FATF recommendation in the legislation, but that had no effect in reality on money laundering. So FATF decided that they were going to come up with a new system, the risk-based approach, and they would start assessing effectiveness. And this is where the problem starts when you're talking about lists and everything. So Mauritius was assessed by the ESAMLAG in 2006. Well, the assessment started in 2016, completed in 2017, published. The report was published in 2018. So it's quite a long process. And when the MER came out, we were deemed to be non-compliant on a number of recommendations. Some of it we simply were not compliant because we didn't have the legislation. Some of them we deemed that we were compliant and disagreed with the assessors, but you know, the time is past for arguing. But we also had an issue when it comes to effectiveness, like many countries around the world. Okay. One thing which is important to note, you were talking about the press earlier, is that many articles have been published about the situation in Mauritius, and many of them erroneous. The MER, many of you will go and read it probably, it's already outdated. It was outdated the moment it was published. And the reason why is because the MER doesn't just appear. There's a number of draft reports which go back and forth between the country and the assessors. So before the publication of the report, we already made the changes to the legislation. So this is, you really, if you really want to understand, you have to go and look at the follow-up reports. This is where you get the actual situation. But one of the issues that we had was effectiveness, like many countries around the world. And Mauritius was given a one-year observation period. We were deemed to be insufficiently effective on all of the immediate outcomes. There's 11 of them that measure effectiveness. On all of them, we were either low or moderate. So that was an issue. In the meantime, we've managed to, in the one-year observation period, we've managed to satisfy the requirement for 1, 2, 6, 8, 9. So five of the immediate outcomes have been dealt with. The remaining ones, some of them there's quite a bit of work to do. Others, there's very little to do. Okay. So this is what's left now. And as a result, the FATF put us on its grey list, what is referred to commonly as the grey list, which the official term for this list is a list of countries under increased monitoring. And they have given us an action plan to implement by September 2021 to complete all the action items in order to demonstrate the effectiveness on the remaining immediate outcomes. Well, I have to say that the conclusions of the FATF were not a massive surprise for us. For example, the FATF said to us that we did not have an effective supervision system for designated non-financial businesses and professions, the DNFBP sector. So that means lawyers, real estate agents, casinos, dealers in precious metals and precious stones, accountants, etc. Yeah, this is something new. The FATF standards are starting to focus on these businesses and professions. Well, I started focusing on them for the last few years. We're in the process of implementing. So we were expecting that, and we already started working on it. We're already in the process of implementing at the level of the various institutions. So we have set a target, which is end of August, to at least complete all the action items. This is an internal deadline. So we are trying to complete it as way before the FATF deadline.
Okay.
Yeah.
All right. So we've got a plan in place. We've started moving. We're now listed. So
well, we started moving even before we had the plan.
Exactly.
Because the plan is based on the FATF recommendations and the IOs. So it's not rocket science. Yeah.
Great. Well, if you've just joined us, we are one question in already, with Guillaume giving us some history and some context around us being on this list. Please don't forget to send through your questions for our Q&A session at the end. Okay, so moving on to the Economic Development Board, Faraz. It has been claimed by the government of Mauritius that the EU has not adopted a consultative approach while issuing its latest list. Can you share your point of view on how we should tackle this perceived unfairness?
Thank you, Mark. There are two ways of looking at this legitimacy issue surrounding the EU high-risk list. Firstly, there is the procedural aspect of when the list was published, and this we believe, and when the methodology was published, and this we believe puts into question the legitimacy. And secondly, I'm just going to piggyback a little bit on what Guillaume said as well. There is the crux of this entire matter, which is what has been the progress that Mauritius has made since 2017 on this AML-CFT front, and whether this has been factored by the European Commission when they placed Mauritius on that list. So let me take the first one to begin with. Okay. The regulation was published on the same day that this delegated regulation was published, on the same day that the EU adopted this methodology, and they did that unilaterally. So we were all taken a bit by surprise, because we did not have a forum to make any explanation. We were unable to make any representation whatsoever. We were not consulted. We were not heard. And they just published the list just like that. Before this regulation, there was another regulation by the EU that said that when they place a country in the risk, or when they are going to place a country in the risk, they have to have a consultation of at least for some period of time. So what happened to this methodology of going forward with the publication of the list? And most importantly, there are fundamental rights at stake, because when a country is placed into a list, there are sanctions, enhanced due diligence, the cost of doing business increases, countries or probably banks stop to deal with that country. So there are economic repercussions, especially in this during this pandemic that we are facing. Yeah. So we believe at the level of the government that our fundamental rights to be heard were baffled. And then when we talk about legitimacy, Mark, we go into the more pronounced aspect of it, which is, and Guillaume touched a little bit earlier on, the EU took the FATF list and then came up with their list, right? So FATF has the blacklist and then the light gray, dark gray list, right? Yeah. And Mauritius was, allow me to say, in the light gray list. EU conflated all of these lists and came out with a single list. and they treat the same way they treat other countries in the blacklist, the same way they treat the countries in the grey list. And then it troubles us a little bit, because there are some countries which were on the FATF's grey list and they are not on the EU's list. And then so it questions the fairness that this entire list has. And then to wrap up on this a little bit, without taking too much of time, the crux of the matter is what we have done on the AML-CFT front, and Guillaume has enumerated it beautifully. But when we started in 2016, 2017, we were only compliant, or largely compliant, with 14 out of the 40 FATF recommendations. When this list came out, we were compliant with 35 out of the 40 FATF recommendations, and this is one. Secondly, because we are part of the ICRJ at the level of the FATF, we had to report on the progress we were making. So on the 20th of March of this year, notwithstanding the lockdown that Mauritius was experiencing, Mauritius already submitted a progress report to the FATF. And it was up to the FATF to assess the progress report. And because of this COVID-19 pandemic, the FATF pushed the assessment by 1 quarter cycle. So Mauritius, the progress report submitted by Mauritius was not assessed at the level of the FATF. But that doesn't mean to say that we have not made progress. So when the EU published this list, our question is, did you see the progress that we have made so far at the time that you're publishing this risk? At the same time, you know, we did a number of re-ratings, etc., to come where we are. And within one single year, out of the 58 recommended actions, within one single year, we did 53 recommended actions, and we still have 5 more to do. So is that enough to place us on a list? And then let me end on this one for now, Mark. Yeah. You know, most of the non-conformities, and I'll weigh my words here, the non-conformities that Mauritius has is with respect to the domestic sector. So it is a bit, how shall I say it, a bit mind-boggling to see how domestic jewelers based in Mauritius and you know, bookmakers, etc., how their actions are going to impact on the EU's financial system. So can a jeweler in Mauritius do so much of you know, non-compliance with AML-CFT regulations and laws that it impacts on the EU's financial system? So these are food for thought, and these are our way of looking at it, and this is why I say, you know, it questions the legitimacy of this risk, of this list. Sorry.
So I think that's definitely a controversial topic at this point, looking at the different things that we have met, the different points that we have achieved, and yet we still find ourselves in this position. Okay, Faraz, thank you. Let's go legal. This question is directed to Nicolas. How far does an armada of laws, including enactments and amendments, help a country in mirroring out its intention and commitment? You know, Mauritius operators and even clients complain about over-compliance while our country is being blacklisted. Please share your views on this paradox.
Thank you, Mark. The question seems to be a bit complicated, but I'll try to have a simple answer to it.
Great, thank you.
So when you look at the paradox of compliance, when we talk to clients and even operators in the financial services sector, they have the feeling that there is over-regulation in that sector.
Okay.
And at the same time, we are on the blacklist. Just to take some concrete examples, I was, just before the lockdown, I was going to an insurance company to renew my car insurance. And the guy next to me was really complaining about the number of documents that he had to submit just to renew his car insurance. Yeah. They were asking for a proof of address, utility bill, etc. And he was a lay person. He couldn't understand all the implications of that list. And he was saying, I've been a client for more than 15 years with that insurance company. Can't I renew and I'll bring back the documents later? But he was told that they needed these documents to be able to renew his car insurance. At the same time, when you are dealing with clients, even from Europe, I had a call last week, even with clients from France, wanting to open a bank account in Mauritius, and they were asking about whether all the banks were requiring this famous bank reference letter that is required to open a bank account in Mauritius. And they were saying that in France, they have been opening a lot of accounts, but they had never been asked for such a document.
Yeah.
So you can see that, as Guillaume pointed out, Mauritius is deemed to be deficient in terms of KYC, but I think we are one of the countries where it's quite complicated to open a bank account or to open even a company compared to some European jurisdictions or even some US states that we all know, but that we can't cite today. So, as pointed out by Guillaume earlier today, adopting a set of laws and regulation is no more sufficient. And we need to show now that there is proper implementation and proper enforcement of those laws.
Okay.
And Mauritius has already started doing some job in that respect. And this has been recognized by the FATF and even the EU. And in terms of the activity of a law firm, for instance, last month there was a guide which has been published by the Attorney General's Office in collaboration with the FIU, AML CFT guides that will be applicable to all law firms and all law practitioners. We would even be required to appoint an MLRO or a compliance officer, depending on the size and the nature of the business. And it's another step towards complying with all the requirements of the FATF and the FIU. And we all know that in terms of on-site inspections, the FSC has also beefed up its program, and they are doing a lot of on-site inspection, leading to more compliance and more effectiveness in that regard. And the cabinet has, like 2 weeks ago, announced that they would be complementing the existing AML CFT laws with other regulations. And we don't know yet what will be the details of those laws and regulations, but maybe they would go, to show that they mean business, maybe they would go like Singapore, like criminalizing certain offenses. Like in Singapore, people, financial operators who help foreign citizens to do tax evasion,
Yeah.
they would be as if they would be indulging in the tax evasion offense themselves, and it's a criminal offense there. So maybe to show that the government means that they would go into that direction. And we also have in the budget the announcement of a financial offences court, again, to show that we mean business and that there is a proper implementation of all the AML CFT rules.
Okay.
And to conclude, I would say that there may not be additional measures in terms of AML CFT compliance or over-regulation, but we can maybe use the technology to try to streamline the process. And they have announced in the latest budget that there is a project of centralized KYC that would help in the setting up of business. If you've already submitted some KYC documents with a company, you wouldn't need to submit it
Again,
10 times. Yeah.
Okay. All right. I mean, that makes a lot of sense. Yeah, it would be nice if we did start streamlining documentation that needs to be submitted. So it seems like we head in the right direction, at least. The conversation is out there, and go for it.
If I may just add something about, for example, the changes that we're bringing to legislation.
Yep.
So when FATF is assessing effectiveness, one of the things that they look at is the investigatory process. That's immediate outcome 7, which is prosecution and investigation and prosecution of money laundering offenses. So they will look at the number of suspicious transaction reports received by the FIU. They will look at the number of intelligence reports that have been disseminated by the FIU to law enforcement authorities. They will look at the number of investigations that are taking place. They will look at the number of prosecutions that are taking place, and then they'll look at the number of convictions. And it has to follow. One of the problems that we have in Mauritius, and we're not the only ones, many countries, particularly former British colonies, have the same problem, is that you have everything except the convictions. And the reason why is because the cases take too long in court.
Okay.
So one of the solutions that we're bringing, and many countries have done this around the world, I'm thinking about Channel Islands and countries in the Caribbean have had to do the same thing to comply with FATF, is come up with a different court that deals only with this issue of financial crime. So we don't have these cases being, lost in the the alcoves of the of the court system in Mauritius. So this is what we are addressing, because that's how FATF works. That's why I was saying earlier, if you read the articles in the newspapers, many people don't understand how the assessment process takes place. It's based on the statistics and the numbers, and there is a problem at one point. So this is what we're trying to fix.
Okay, so there's got to be the right ratio happening between all of it. Exactly. Otherwise, we're not owning the issue. All right, thank you for that. Let's hear from the banking sector. Yogesh, let's talk about how this will affect banking transactions and wire transfers. A direct impact of the EU listing shall be that EU-centric transactions sourced from Mauritius shall be subject to an enhanced due diligence screening. For our audience, please can you share your views on what they would be expecting from banks as enhanced review, as well as any additional screening measures that need to be adopted?
Thank you very much, Mark. Before I talk about the potential implications of the blacklisting of Mauritius by the EU, I think it is quite important to give you a little bit of background on the banking sector itself in Mauritius. So as of today, we have got 20 banks registered, licensed, and well-regulated by the central bank in Mauritius. Some of these banks are intricately linked to the global business sector, in that they are facilitating a lot of the transaction flows with respect to cross-border investments, with respect to international trading. Some of the banks also act as custodian for assets of high net worth individuals and investment funds. Out of the, these total 20 banks in Mauritius have got a total assets of approximately $35 billion as of the 30th of June 2019. Wow. And the global business companies' deposits, assets, represent approximately 34% of these $35 billion of total assets as of 30th of June 2019. Now, if Mauritius goes on the blacklist in effect come 1st of October 2020, European financial institutions will be required to apply enhanced due diligence to financial transactions and business relationships to countries that are listed. Now, it should be noted that the EU legislation and the EU directive actually defines enhanced due diligence. And what does it mean exactly? So the definition basically means that additional steps need to be taken with respect to identification and verification, but with a risk-based approach. So in practice, what can we expect? Effective 1st of October 2020, if Mauritius is actually blacklisted, so we may see our European counterparts, the European banks, looking and examining and scrutinizing financial transactions coming from Mauritius and going to Mauritius. So that would mean that European banks may want to understand the background of transactions, They may want to understand the purpose of the transactions and the whole rationality of these transactions. Secondly, the European banks may want to obtain additional information, supporting documents related to these transactions. And this is quite subjective. If we take the example of, let's say, an international trading transaction, one European bank may be satisfied with a copy of an invoice. Another bank may want a bit more than that. They may request for a copy of the bill of lading. Another bank may look at an agreement. So this is quite subjective.
Okay.
Thirdly, some banks may even go further by wanting to have information about the source of funds and the source of wealth. And others may, and we hope not, they may even be looking at the beneficial owners of the structures which are registered in Mauritius, i.e. they may want to KYC and CDD the ultimate beneficial owners of global business companies registered in Mauritius. Last but not least, in terms of the correspondent banks, we may expect that they would be doing more regular reviews of the business relationships that they have in Mauritius, i.e. they will be doing more regular reviews of the banks that they maintain relationship with in Mauritius, and there would be also enhanced and more regular transaction monitoring. So, Mark, to conclude, all of this, it goes without saying that this will take longer. There will be a longer timeline in order to complete the transactions.
Yeah.
And also in terms of the compliance costs, that would add to the compliance costs to all stakeholders in Mauritius.
Okay, so that becomes quite a complex experience, and obviously something we want to avoid as much as possible. Obviously, clients or the client's always right, and we always want to make the client experience really, really good. So making life more difficult indeed. All right. Okay, so let's move on to how this affects the global business sector. Mauritius has been an international financial center for more than 25 years now, and the global business sector has attracted investors from around the world. Jimmy, this one is for you. In terms of the 5 outstanding points related to the FATF recommendations, 2 points related specifically to the global business sector. 1, Mauritius has to demonstrate that the supervisors of the global business sector implement risk-based supervision. We've touched a bit on that. And 2, Mauritius has to ensure the access to accurate, basic, and beneficial ownership information by competent authorities in a timely manner. Could you expand on how we're going to meet these requirements as a country from a management company perspective?
Thank you, Mark, for that question. So I'll take the first question. And I'd like to lay emphasis on 2 words specifically.
Yep.
Demonstrate and effectiveness. And I'll explain why. In Mauritius, we have a long-established risk-based supervision framework, which is clearly laid out in the FSC AML/CFT code, which is applicable to all its licensees, including management companies. So we, as a practitioner in Mauritius, we have to strictly adhere to all these guidelines, regulations, legal framework, in which risk-based assessment and risk-based approach plays an important role. So we ourselves, as a management company, we adopt a risk-based approach when we accept new clients. We have a risk scoring card, very clearly laid out with clear guidelines as to how we assess a client from a risk perspective. And all of this is regularly checked by the regulator, namely the FSC, through on-site visit and off-site visit. So why I lay emphasis on demonstrate and effectiveness is that I think it would be more challenging for us as a country to address this point if we did not have a risk-based approach framework. Yeah. To put this in place in such a short period of time would have been quasi-impossible. So what we're saying is we do have this risk-based approach, but the emphasis of the recommendation is demonstrate to us that the effectiveness of the risk-based approach is there, and show us that you are, as a supervisor, as a regulator, exercising your duties and function to make sure that people who are supposed to follow this rule are following this rule. So as I was saying, over the past few years, and in fact, for a long period of time, there's been regular on-site visits by the FSC, off-site reviews. And right now, as we are speaking, the FSC team is in almost all management companies carrying out reviews. So all our people are busy with that. So I think the challenge for us as a country in addressing this specific point is, well, on these two words that I've chosen to elaborate on, i.e. demonstrate the effectiveness of the risk-based approach. And I think this is what we are, as a country, addressing. And I think all the measures are being taken for us to be able to meet this recommendation in a shorter period of time than what we were supposed to. But I think all the resources are being put in place for us to be successful on that front. So that's question one. Question two was about beneficial ownership. I think it's important to understand that as far as management companies is concerned and global business entities, we have what we call a two-tier level of supervision, i.e. we have the management company who accepts the client, who does a due diligence and KYC check on the client. And once the management company is satisfied that all the beneficial ownership details are available, then it would submit an application to the Financial Services Commission, who would again do a beneficial ownership check on this client prior to giving a license. So we have this, that's why we call it a two-tier level of supervision regarding specifically the beneficial ownership. And then we have a third layer, an additional layer, which is what Yogesh has mentioned, exercised by the banks, because invariably all these entities would have to open a bank account. Okay, so the bank would also do their own checks and procedures on beneficial ownership. So I think there's two official layers plus a third layer by the banks for beneficial ownership. And again, I think the information on beneficial ownership is there. It sits at one of these three levels, in fact, at all three levels. And again, the action point that we would need to take is that, again, the word demonstrate is there. We need to demonstrate progress, that access to this information, which is there, should be able to be obtained by the authorities as and when they need it in a quick and efficient manner. And I think this is, again, the task we are setting ourselves as a country in doing and demonstrating that, yes, the information is there, but maybe what we have to work on is demonstrate that it is easily accessible to the authorities as and when they need it. So again, the initiatives being taken in that respect are numerous. Yeah. And resources are being put to achieve these objectives. So I think the important thing to note is that we have the framework in place, we have the rules in place, all the players in the industry are strictly adhering to these rules. What we need to do now is demonstrate that the effectiveness of what has been put in place is there.
Great. So yeah, I mean, it becomes complex when we're faced with this challenge, because Mauritius is known to be an ease of business country. And that's why we started attracting a lot of investors. So obviously something we need to navigate quite carefully. Going back to Faraz now, how far do you think that bad publicity by the proposed inclusion of Mauritius on the EU blacklist can cause more harm to the repute of Mauritius as a destination for investment? And do you think, as an international financial center, we are doing enough to defend our position? Maybe just briefly share the initiative taken by the government to that effect.
Sure. Mark, this answer is going to be more of a lament, right? Mauritius has forged a reputation as a premier international financial center of choice and substance for the past 25 years. We have done that at the back of our ease of doing business, the excellence, hard work, and the quality of the services that we offer, right? Cost of business, ease of doing business, but quality of the people, quality of the services that we offer. So of course, I mean, we naturally are very much aggrieved by this. And let me share this with you, that even at the level of the supranational institutions in Mauritius and the government. We're all very much concerned of having been placed on that list. And you would see there is an official communique last week or the week before that from the Prime Minister's office, committing and saying at the highest level that we are going to do everything to convince the European Union, and we are going to make sure that we come out of this list and out of the FATF list. So, you know, we have ensured that we are not subject to the tax haven tag, and we have done that for the past years. We have said how there is an equal taxing right, how the tax treaties work, why there is a rationale, there is a business commercial, and there is a viable reason, and there's a multitude of reasons to that effect of why investors choose Mauritius as their hub for investing cross-border for their wealth management, etc., into Africa, into other emerging markets. So there are a multitude of reasons. And now we are on this list of AML-CFT when we have done everything that we were supposed to have been doing to ensure that we adhere to the international norms and standards set up by the FATF. And you know, let me share this with you as well. I mean, Mauritius formulated and agreed upon a detailed action plan with the FATF with a completion date of September 2021, right? We nevertheless aim to complete this process by December 2020. But given the fact that we have been placed on this list, we have since decided to further accelerate this process with the final completion target date of September 2020. At the same time, you asked me what we have been doing. There have been numerous engagements amongst the various relevant stakeholders in Mauritius with the European Parliament, with the Commission, with the Council, and as well as with the FATF Secretariat. So we are leaving no stones unturned to ensure that we are not in that list. And at the same time, and I think this is extremely important, there is not only the level of government's commitment, but as recently as last week, the Honorable Minister of Finance, Economic Planning and Development read the budget, the national budget of Mauritius. And he stated clearly that Mauritius will aim to comply with the remaining recommendations of the FATF by September 2020 through the following measures. And these measures are juxtaposed or should be juxtaposed with the 5 recommended actions that we are yet to comply out of the 58 one. So the first one is risk-based supervisions in accordance with the recommendations of the FATF. Second one is targeted outreach programs to promote clear understanding of money laundering and financing of terrorism activities. Third one is increased reporting of suspicious transactions. Fourth one, and Guillaume talked about it earlier, targeted financial sanctions in cases of terrorist financing. And fifth, timely access to beneficial ownership information. There is, of course, again, the Minister of Finance announced that there will be a new AML and CFT miscellaneous provisions bill, which is going to be introduced to complement on the existing legislative framework. And my friend here talked about the Financial Offences Court, which will be another addition of Mauritius to speed up all that is needed with regard to complying with the FATF and, you know, with the EU standards.
So, yeah, I mean, we headed in the right direction. We know about this. We've known about it for some time. We've taken the action already before going onto the list. And all that seems to be happening is that we are fast-tracking our efforts, which obviously puts a lot of strain on resources that we currently have, so causing some issues. A reminder to you guys watching at the moment that we're about to approach the last question. So if you would like to send through your questions, they are being curated at the moment. They're popping up on my screen, and we're going to be addressing those questions shortly. All right, so as you guys know, I'm not the professional around this topic. I'm here to learn, as everyone else is that's logged in to watch. So this may sound like an ignorant question to the average man on the street, the budding entrepreneur, post-COVID-19, to sort of give it that context and what's been really important to us currently. But do we care about this listing? And does it really change how we grow as a country and community? This question is, sorry, to all of you. So please feel free to answer. Maybe we can start at the end with Yogesh.
Yeah, thank you, Mark. Well, I think this is probably the first time that Mauritius is potentially going on a blacklist of the European Union. And it goes without saying that it should be a matter of concern for each and every one of us. More specifically, those who are involved directly or indirectly with the financial services sector in Mauritius. However, I personally believe that we should not worry and that there's no reason to panic. Mainly because this is, first of all, a potential blacklisting. The effective date, as we know, is only the 1st of October 2020, and today we are the 10th of June. So we have got time in order to address the issue. As my colleague Faraz just mentioned, the Mauritian government has already made strong commitment in order to address all the deficiencies that have been identified by the FATF, and these will be addressed and will be addressed in time. Insofar as banking is concerned, I think it's very important to know, for the audience to know, that the FATF report which came out and where Mauritius got grey listed, and here again, I think it should be highlighted that Mauritius finds itself not in the dark grey list, but in a light grey list, which means that Mauritius has already made its commitment to the FATF in addressing the 5 deficiencies that have been mentioned before, and that we are swiftly and promptly addressing those deficiencies. So it was the FATF report did not target the banks. It targeted the non-financial businesses and professions, the likes of lawyers or accountants or real estate agents or bookmakers or whatever, horse racing. It did not target banks. On the other hand, it was mentioned clearly in the report that Mauritian banks apply the highest standards in terms of AML CFT controls. And Nicolas mentioned it before, like, for example, a bank reference letter. Without a bank reference letter, if you want to open a bank account in Mauritius, you can't go far. It is a mandatory document which is required. Last but not least, I believe that if ever Mauritius falls in the blacklist come 1st of October 2020, yes, there may be more scrutiny on transactions, more examination of transactions, but that doesn't mean that all transactions would be blocked, all transactions would be stopped. I think transactions would still go through, but there will be an enhanced due diligence carried out on these transactions. So banks, I believe, are well ready for that process.
Okay, great. Anything from you, Faraz?
Mark, I'll give a quick answer to that one. The operators, the banks, the management companies are going to find ways and means to navigate through this for the benefit of their clients and the international investing community. I also believe that the quality and the level of sophistication of our international investors would essentially mean that our investors are aware of what Mauritius has achieved so far and whether we deserve to be on that list. But the fundamental question for the government of Mauritius is, for the government, we do not have the luxury of being in a list, right? Especially when we have done so much, and we have always been proud to say that we adhere to all best practices and international standards. So from the government side, notwithstanding the operators, the banks, the management companies, I think from the government side, we are going to continuously strive to bring in reforms. We are going to take the measures that are needed, and we are going to ensure that we get out of this list.
Great. Thank you. Nicolas.
Thank you, Mark. So from a law firm perspective, working in the financial services sector, as mentioned by Yogesh, it is a source of concern that we are on the list, but we shouldn't panic. There is a strong commitment from government, as mentioned by my colleague on my left, and I believe that if we implement all the right measures, we'll get off the list. But I must say that from my perspective, the day after we got the news that we were on the list, I got queries from law firms based in the US or in the UK asking for our views on that listing. Some of them, they work for private equity firms that are looking at a jurisdiction to set up their next fund. And they were saying maybe until October, they won't be looking at Mauritius to set up their next structure. It's the same thing that when you're looking at projects in Africa, in infrastructure or renewable energy, most of the founders, they want to attract EU institutional investors. Yeah. So in Mauritius, we've got a lot of EU institutional investors that invest in those projects when they need capital at the beginning to raise funds. And this would make Mauritius less attractive for them, and maybe due to government pressure or policy decisions, they won't be able to use Mauritius to invest into projects in Africa, which has been the case for the last, I would say, 10 years or so. Yeah. And even for local clients, as Yogesh mentioned, there's no need to panic. The French client who operates in the renewable energy sector in Mauritius, he wanted to set up his holding company to promote the projects he's looking at in Africa. And then the week after the list was published, he said that his French investors didn't want to use Mauritius anymore as a jurisdiction. And as I said, you shouldn't panic. Don't take the decision too quickly, because the list is not yet effective. It will only be effective as from the 1st of October. And given the commitment that the government has shown, and given all the measures taken, as announced by Faraz a bit earlier, I'm fairly confident that we'll be removed from that list before the deadline.
Justifiably so, yes. Cool. Guillaume.
Thank you. Yeah. Well, should we be worried? Well, the question is twofold. The answer is twofold. On the one hand, I don't think we should be worried, because when you look at the deficiencies that we have in Mauritius, they relate mostly to the NFBPs, so designated non-financial businesses and professions. They don't really touch on the banking sector or the financial sector. Only the issues that were mentioned earlier with Jimmy about inspections and BO, which has to be organized and given timely access. This is something that we're working on. It will be done within the next few weeks. So in reality, you don't really have to worry about the jurisdiction itself. If you want a good example, there is a document, I know I shared it with you earlier, with the consolidated ratings of all the countries that have been assessed so far by the FATF. And if you look at all the ratings, what they've done is the FATF has consolidated everything in a color-coded table. And you realize that when you look at effectiveness ratings, Mauritius is very similar to other countries in that respect. The reason why many countries are not on the FATF list, and I talk about the FATF list because that's the source of the issue. Yes. The reason why many countries are not on that list that have been assessed is because FATF has a prioritization criteria. And the prioritization criteria means that the size of the financial sector assets in that particular country has to be above $5 billion for it to be considered for listing. So Mauritius is a victim of that. Mauritius is also a victim of the timetable. We're one of the first countries to be assessed, meaning that we did not have time to properly address all the effectiveness issues. When FATF assesses effectiveness, they look at statistics going back 5 years. Well, when you're one of the first countries to be assessed, it's a bit difficult to produce proper statistics, especially given that we're dealing with a new assessment system and we're dealing with a new methodology and there is no hindsight. Countries being assessed next year and the year after will have all the previous reports to work on their own system. So in that sense, I don't think it is a problem. And given that we're working very hard on getting off the FATF grey list, I don't think it is a major issue. The issue is perception. Once you talk about blacklist and you see Mauritius being in the same list as other countries such as North Korea, which is a country that has never collaborated with any international organization in relation to AML-CFT or anything else for that matter. It creates the sort of situation that Nicolas just described, where clients say, well, you're on blacklist, we don't want to deal with you anymore. Yeah. And this is the issue. Because a lot of these clients, they don't actually go into the detail to understand what is actually the problem. Yeah. So this is why we have to deal with it as quickly as we can.
Okay. Jimmy.
So you asked the question about whether we care about being on the list or not.
Yeah.
We do care enormously. We care enormously for many reasons. One of the reasons Guillaume has just mentioned is perception, and that's extremely important, especially for the financial services sector. I think it's quite paradoxal because, as I think Yogesh and everybody else, my colleagues here have stressed, the shortcomings, as it were, that have been identified by the FATF relates to more of the sectors, domestic sectors that Yogesh mentioned, and not specifically the banks and not the financial services sector, namely the global business sector. But it's paradoxal that the two sectors that would be the most affected in case we are listed would be these two sectors who are not to blame, as it were. Yeah. So it's a tricky situation that we have to get out of. So yes, we do care about not being on the list. And I think we as a country are doing everything we can to not being on the list. And you also ask whether as a country we will get on as usual, if ever we were to be on at least rather unfairly. Yes, I think we are a resilient country, as we've shown in the past, and we'll continue to show. We'll get through this, but I think the task at hand is really to get removed from that list.
Great, thank you very much. Right, so a lot of insights, a lot of clarity brought around this topic. I'm certainly learning, as I'm sure all of you are learning right now. And so we're going to dial into the Q&A session. And so I'm just looking at, the questions that are coming through. Right. To all of you that have joined us, I just want to say thank you very, very much. We currently have 332 of you that are on board, so that's fantastic. So we're definitely spreading the news. All right, question. I just want to check which question we've got here. What discussion do you have with the EU to change the listing? So, EDB, let's go with you. What discussion do we have with the EU to change the listing?
Oh boy, okay.
Difficult. I read that question with trepidation. Otherwise, I'll ask that question.
I'm just going to say that, it is certainly not the forum to discuss on the discussions that probably the government is going to have with the EU, is having with the EU. But it's a very important question because I think the audience wants to know where are we at with regards to the process and the discussions with the EU. I think that the tone of the discussions and the substance that is going to be discussed with the European Union is already enumerated in the communique issued on the 2nd of June of this year from the Prime Minister's office. where you would see that, you know, the government of Mauritius stresses that the European Union has been a privileged partner with Mauritius in terms of, you know, in terms of trade, investment, cultural aspects, etc. And you would see that the word used in that communique is that this relationship, this privileged relationship that we have with the European Union is on the verge of being compromised. So you already get the essence of the tone that is going to be used with the EU. Having said that, the communique goes on to enumerate the substantive provisions, including the right to fairness, the right to be heard, the right to be consulted. At the same time, the progress that Mauritius has made. So these are, in a nutshell, the guiding principles of the discussions with the EU.
All right, that's a diplomatic answer. Let's check out the new questions. Yeah, just getting in some from our team. Right. Give me 1 second. This is always a work in progress, as we know. So it seems that, or I think we've kind of answered this, but it seems the EU have not adopted a collaborative approach. What is currently being established what is being done to establish collaboration with the EU representatives? I think we've kind of gone through that. According to the OECD, the issuance of residence or citizenship through investment schemes can be misused to hide assets offshore. Last comment. Following the new budget whereby the government is encouraging such schemes, do you think this could have an impact on the assessments of the FATF EU?
No. Simple
No.
answer.
Great.
FATF, from the FATF perspective, no. And the reason why is because the FATF does its assessment according to a methodology, and it is a well-defined methodology. The only issue that countries are having with the FATF assessment when it comes to effectiveness is that in order to get off the list, you have to demonstrate that you're doing the words being used by the methodology are tangible and positive progress towards achieving effectiveness, and the manner in which tangible and positive progress is measured is subjective. So this is a difficulty that we are all facing, all the countries being assessed are facing, including Mauritius. But issues of residence permit and whatnot, it doesn't matter because it doesn't fall under the FATF recommendations.
Okay.
And just
Go for it.
Just to piggyback a little bit, I think the question is more of also on tax matters and whether, you know, whether the granting of a residence permit in Mauritius or a citizenship would automatically give right to, you know, being blacklisted by the OECD. Again, the answer is no, even for tax matters, because there are two things. Residency is one, that is residency in Mauritius and the ability to stay and live and work in Mauritius, which is governed by presumably by the EDB Act and the Immigration Act, amongst others. The tax residency is governed by the Income Tax Act and you know, the provisions on when and how a person is determined to be a tax resident in Mauritius is determined by is enumerated in that act. And the process is fairly straightforward. So let's not conflate issues.
All right. So there's no crossing over on that topic. All right. So talking of effectiveness, Mauritius has identified and listed 2 high-risk countries, namely Iran and North Korea. Section 17H1. Till now, no authority has communicated the Mauritius list of high-risk countries, while communication of the aforementioned list should have been done immediately as per Section 17H5. When, like I said, I'm not the expert. Anyway, when can the licenses, regulated entities be made aware of the existence of such a list?
Well, I don't know. I would have to ask the ministry for this because they're the ones responsible for designating. It happens at that level. But one thing that I can say about the listing, because all countries are supposed to be listing countries. That's under the FATF recommendations. You will find under 19. Recommendation 19 says that countries should have the ability in their national legislation to apply enhanced due diligence on countries for which FATF has called for enhanced due diligence. And it also says that countries should have the ability in their national legislation to apply countermeasures, which goes beyond enhanced due diligence, against countries for which the FATF has called for countermeasures. So these two countries are in the FATF blacklist. So this is why we're following the FATF recommendation on this point. Recommendation 19, interestingly, also says that countries can go beyond what the FATF recommends, but if they choose to do so, it has to be based on risk and it has to be proportionate. This is where we have an issue with the EU, because what they're doing is not based on risk, nor is it proportionate. No. It's just copy and paste.
Copy and paste. Right, copy and paste. I'm seeing some humorous comments. You know, people feeling that this is unfair. It seems to be a theme that's running through in this conversation today. I just want to check with our moderator if we've got some more questions coming through. And all right, so question for us. What about an action list to meet the FATF expectations on the 5 key points and the possibility to follow the progress every day available on the EDB website to communicate the progress? I mean, I think this is it's a magic wand. It's a cool idea. It's
a good question. Let me reassure the the audience that there is a multi-stakeholder committee presided by none other than the Prime Minister, looking at the progress that Mauritius is making at the level of the action plan. At the same time, there are committees presided by the Financial Secretary, amongst others, that look into specificities. Yeah, once a week, there are meetings nearly every day. But I don't know, is it prudent to just show the progress on the EDB's website? I don't think so. It would do more harm than good. But rest assured that there are meetings that are being presided by the Prime Minister, by the Ministry of Finance, etc., and the Ministry of Financial Services in these matters.
Great, thank you for that clarity. We just want to check on with our production team at the back. We're running through on some questions. And my eyes need some readjustment. 1 second, please. Could and should this situation be avoided? Or the evolution and development, I think it's supposed to be evolution and development of Mauritius as a sound and well-regulated international financial center weaken in view of the current situation? Who would like to answer that? Anyone? Go for it.
Can you say the question
again? Yeah, you seem pretty. All right.
Could we have avoided?
Could we have avoided the situation that, and will it weaken us as an international financial center?
Well, it has weakened us as a financial center.
Yeah.
I think the first one is, could it have been avoided? Well, it would have been had the EU published its methodology earlier on, and we had been able to comply. First thing. Second thing is, there would have been no situation to avoid had the EU give the legitimacy to the FATF and the timeline imposed by the FATF to get out of this list, which was by September 2021. So, the government of Mauritius, we agreed with the international standard setter, which is the FATF. And then we embark on the action plan, on implementing and on progressing through it. So I think that situation, whether it could have been avoided, is more on the pointer that I made on the legitimacy of this list to begin with. And secondly, does it weaken our position? I think, well, I stand guided by whatever the operators have said on this panel, and also to the sophistication of the international investors. But having said that, the government is very committed to get out of it.
Another question we're getting is, are we able to get on the whitelist?
Is it to me?
Yeah, let's go for it, yeah. Are we able to get on the whitelist before the due date when the blacklist would come into effect.
Guillaume.
Yeah, Guillaume?
What do you mean by getting on the whitelist? Because
being on the blacklist.
yeah,
Basically,
on
not
the
being on the blacklist. So getting
Um,
into a non-over supervisory, yeah.
of the FATF.
Yes.
I'm not so sure because it depends on when the FATF will give us the all clear. So it depends on when we submit the reports and when they're holding meetings
Gotcha.
with all the COVID. All the pandemic, all the meetings have been moved around. So we are not so sure when we'll get off the blacklist. The target that we've set for ourselves is to complete the action plan, because that we can do. That's within our control. So we're completing the action plan in order to present this to the FATF, and then we'll see when they decide. Yeah.
Okay. So it's a process of time and a process of getting through all the milestones as a country, as various bodies. All right, so I've got another question coming through. Just 1 second here. It's listed an important question. How should we reflect the position of blacklisting in our advice to international clients, considering Mauritius as a place to incorporate companies or structure a business? So just to say that again, how should we be communicating or reflecting our position of this blacklisting to clients of international base regarding incorporating companies and setting up business structures? Let's go for it, Jimmy.
Maybe I can offer an
Great idea.
answer from a practitioner's point of view. I think, as I've mentioned before, the framework is here already. So
Yeah.
a client who wants to set up a GBC company today, after the publication of the delegated regulation and before, has to go through the same stringent procedures in Mauritius.
Gotcha.
So as far as client adoption procedures are concerned, beneficial ownership details, everything is the same. And we certainly, as a management company, we ensure that we adhere fully to these norms. So the client, from a client's perspective, it's the same thing. And obviously, we can understand that it's a worry to them that Mauritius is potentially going to be on that list. So that's why I was saying it's important, if anything, only for perception, to do everything we can not to be on the blacklist. But I think it's been stressed upon by all my colleagues here is that they should not rush to conclusions and really should consider the fact and not look at a lot of the misconceptions that are around. Stick to the facts, stick to what the law says here, what the rules say, the practice we adopt. And our weakness is to demonstrate that these are here. Our weakness is not that they are not here, the norms.
Yeah.
So the norms are here. We need to demonstrate that. So fundamentally, I think, for them to set up the companies here in Mauritius, I don't think they should, be unduly worried about the situation.
Got you. So it's just about communicating. It's not that we're not doing it. It's just we need to demonstrate it. And go for it. Yes, Guillaume, please.
Add something on this point. One of the things that has to be understood is that the list itself is quite unfair. And I'll give an example of another country, which is Bahamas.
Yeah.
Now, the Bahamas have been on the FATF grey list, the countries under increased monitoring, for a while, and they have completed their action plan. They have completed it. The thing is, before you are let off the FATF list, the FATF has to come down to the country and do an on-site visit to confirm that what you're saying in your report is the truth.
Yeah.
And then they let you off. The on-site visit has not taken place because of the pandemic.
Okay.
And so they've completed everything. The on-site visit has not taken place, and yet the EU is proposing to include them on the blacklist. This is quite unfair.
Yeah.
This is clearly an exercise of copying and pasting. The EU has not gone into the details of each country to see what's happening and what's not happening on the ground. So when you look at the situation in Mauritius, we know what the problems are. It's listed on the FATF website, and what the action items that are remaining are. So we're dealing with the NFBPs, we're dealing with NPOs. So non-profit organizations, setting up a regulatory framework for them and the risk assessment and everything that goes along with it. So this is where the issue is when it comes to money laundering.
Okay.
So talking to clients, it's important to let them know that, this is what we're dealing with.
It's very, very interesting. I think that we have come to the end of our questions. Nope, sorry, we have one more. You guys okay for one more question? Let's go for it. All right, so Mauritius was put on the FATF's grey list, which led to concerns that trades and fresh FPI registrations from the country could be halted in India. The Securities and Exchange Board of India, which was then cleared. What would be the likely impact in view of our current situation in the securities market?
Continue. You know, when this situation is resolved with regard to India, I mean, the SEBI came out with a circular letter stating that, you know, for all intent and purposes, Mauritius is going to be treated as a country which is not on the grey list of the FATF. They did that following a government's decision where, you know, the SEBI had the prerogative to, you know, to exempt countries from the provisions of the FATF based upon whether they are treaty partners, etc., amongst others. So this issue with India has been resolved, and you know, it's business as usual on that front.
All right, that's great. Thank you very, very much. Right, guys, that's bringing us to the end. To all of you watching, thank you so much for joining us at the DTOS News Desk for this webinar Wednesday. To our panelists, guys, thank you so much for giving up your time this morning and for your insight. It's very valuable and much appreciated. If you would like to know more about future webinar topics, please go and subscribe to the DTOS newsletter. If you are socially minded, go and find us on Facebook, Instagram, and LinkedIn, and you can be up to date with everything that's coming from the DTOS News Desk. My name is Mark Morell, and that is a wrap for Webinar Wednesday. Thanks, guys. Thank you very much.
Thank you.
Great.